Hello, everyone, and welcome to Figuring Out Your First Job and Associate Contract with my good friend, podcast partner, my own dental-focused attorney, Rob Montgomery. This is going to be an awesome show. You're going to get a chance to put questions into the chat. I see people coming in to the Zoom room. A few things I want to share about myself and Rob. I'm a multi-practice owner, own 2 practices in New Jersey, dental coach and speaker, and also the founder of Dentist Job Connect. And we are recording, Rob, on National Nacho Day, and we did celebrate at Nacho headquarters with some vegetarian nachos. So
Nice. Happy
yeah,
Nacho Day, Dr. Nacho.
So it is a big day for us. And my awesome friend Rob is the founder of his leading boutique law firm, Your Dental Lawyer. They have an awesome presence in the dental world and the vet world. He's going to tell you more about that as we come along. But Dentist Job Connect is here to help you hire your associate dentist to unlock more freedom and free time. If you need help from us, we would love to connect with you. Just text HIRE to 215-798-9897. If you are looking for the job of your dreams, not screams, good theme for tonight, text job to 215-798-9897. And everyone needs a good dental focused attorney team. Rob and his team are amazing. If you want to connect with Rob and his team, our Dentist Job Connect team will be glad to connect you, whether you're an associate looking for your first, second, third, fourth, fifth job, a practice owner looking to hire an associate, you're looking to buy a practice, sell a practice, or anything in between. So with that, I am going to unshare and let Rob start sharing his screen. The purpose of doing all these things, I'm impressed how many people are coming into Zoom here on a Wednesday evening. We'll also make the recording available. My team members here, so you can tell us where you are watching in here from Earth. So Rob, I'm going to let you kind of take it away and share your Rob tips. We've been doing this for a long time. The tips I guess there's some updates through these tips throughout the years. Is that fair to say?
Things change.
Yeah. Like dentistry, the legal world changes too. And
Yep.
there's nothing more important than protecting your investment in yourself. And I will share, Rob knows this, we connect with him. The 911 calls I get, Rob, have a lot to do with, is this right in my associate contract? But
Yeah.
sadly, it's after they've signed the contract.
Right.
Horses
Right.
out of the barn. We come up with a lot of cliches, right?
Sure.
So the
Well,
liquidated damages horses out of the barn.
it's just like in dentistry, Paul. Like you much rather treat patients and have well appointments and help people stay healthy
Yes.
than to try to put them back together after they've completely fallen apart.
Yeah, totally. I see people someone's watching here from Maryland. Thanks for sharing with us. So Rob, I'm going to turn it over to you and I'll be back at the end. We'll chat and answer some questions. And so appreciate you sharing with us.
Thank you very much, Dr. Nacho. And again, happy national, is it National
It
Nacho Day?
is national. Yeah, it's a national holiday. Thanks,
Why
Rob.
is it not a world holiday?
I know it should be. It should be. I agree.
All right, thanks, Paul. And hello, everyone. My name is Rob Montgomery, and as Paul said, I have a law firm that represents almost exclusively dentists. We're sometimes best known from the URL of our website, which is yourdentallawyer.com. So tonight we're going to talk about figuring out your first job and associate contract. We're not going to talk about specifics and the details of things, but instead I'm going to just give you some high-level issues and some things to be aware of and some terms and provisions that should raise red flags, yellow flags, or just things that you need to know. So as Paul said, we help dentists with pretty much all of their legal business needs. We don't litigate. I started my career as a litigator. It's probably been over 10 years since I've set foot in a courtroom, and I'm going to keep it that way. But we help dentists with their business transactions, employment agreement preparations for practice owners, reviews for associates, practice sales, acquisitions, from small purchases to very large DSO sales. We also help with partnerships and buy-ins. We do a lot of lease reviews and negotiations for startups and for existing practice owners that are looking to expand into additional locations. So before we kind of start talking tonight about some of the specifics of things that you're going to see in contracts, I just want to talk about what I call contractual awareness. So we're all familiar with the term situational awareness, right? So if you're out at night, or you're by yourself in a lonely place, you're not familiar with the area, you're paying attention to what's going on around you. The same thing kind of applies in the legal world. And I like to call that contractual awareness, knowing what's in the agreement. And so it's not just what the agreement says, because, hey, look, you don't need to be a lawyer to be able to read a contract and know what it says. But there's higher level understanding. What are these terms? What could they mean to you? What kind of practical impact could they have on your ability to practice your profession? Certain other provisions. When do you have to give notice? In this case tonight, we're talking about employment agreements. So when do you have to tell your employer that you're terminating? Knowing what you are obligated to do and when you have to do it. And then also, this kind of goes along with contractual awareness, sort of, but I have to say it because we see a lot of people that kind of trip on this one, which is always keep copies of agreements that you sign. We're going to talk about some specific sort of dicey issues tonight, shall we say. It's a very difficult thing if you're going through a dispute or a problem with your employer if you don't have your employment agreement, because that's what we need as lawyers to be able to advise you as to what your rights and liabilities are. And when there's a problem, that's not the right time to go back to your employer and say, yeah, we kind of had that argument yesterday, or I asked you for something that was additional from a salary standpoint or relief from a non-compete. And can I get a copy of my agreement again? So it's not a good time to do that. So always keep copies of your agreements. So I want to start off tonight, though, when we're talking about a concept called enforceability. What does it mean when you say something is enforceable? A contract is enforceable. A legal provision is enforceable. And we're going to lead off with this because this is one of my number one pet peeves. It drives me crazy when I see people post on Facebook groups or blogs. Don't worry about that. It'll never be enforceable. That non-compete won't be enforced. Those liquidated damages, if you don't give enough notice, will never be enforced. So when we talk about enforceability, that means, will a judge uphold it? Will a court enforce it? Okay. Now, in order to find out whether or not a court is going to enforce a particular provision, it means there's been a lawsuit filed, oftentimes a motion or petition for an injunction, if this is in the context of a non-compete. An injunction is where you ask the court to issue an order telling somebody they can't do something. In this case, they're not allowed to practice in that particular place because it violates their non-compete. But in order to get in front of the judge with that, we're talking about a lawsuit. Complaint was filed, answer was filed, motions were filed, depositions taken, other motions filed, discovery, document requests, a trial, post-trial briefs, sometimes even appeals to find out whether or not something is quote unquote enforceable. And I will tell you folks, it shouldn't come as a surprise. It's really expensive to find out. So, when somebody says, is it enforceable? Don't worry. What I feel like telling people now when I read these things and I cringe, yeah, if somebody says it's not enforceable, ask them for $100,000, right? Why? Because that might be what it costs for you to find out that it's not enforceable. And so, be careful of what that of that word, or falling prey to that kind of advice. You should always assume that if you agree to something in a contract, that it is enforceable. And if it's something that you can't live with, you shouldn't sign the agreement with that in it. So, covenants not to compete. Let's just start off. We're going to keep going with the enforceable word. They are enforceable in most states. So, and unless you're working in a state where they're expressly prohibited, places like California and Oklahoma, it may not make a difference, though, whether or not it would be enforceable, because we just talked about the cost of finding out may be cost prohibitive, but it also can have a great impact on financing. So if you have a non-compete that, just say, arguably is the craziest non-compete that everybody in the world would agree no court would ever enforce it. Let's just say you're in North Jersey and you have a 150-mile non-compete. Well, pretty much, I think everybody would agree that no judge would enforce that. Doesn't matter, because when you go to a bank like Provide, for example, use an example, or other healthcare specific lenders, and you say, hey, I want to buy this practice, and it's within this very unreasonable, what we think is unenforceable radius for a non-compete. Bank says, yeah, we agree. That's a crazy non-compete, but we're not judges. We're not going to give you the money to buy that practice or to start up in that area because it's within that restricted area. You say, well, yeah, but somebody on this blog told me that, don't worry, it won't be enforceable. And the bank will say, well, come back after a court agrees. The other thing to keep in mind when we talk about non-competes, typically they are measured in miles. Now, if you're in a city, especially like New York, for example, it may be measured in blocks. So you agree that while you're employed and for 2 years after, you won't practice dentistry within an 8-block radius of the office. But that's really kind of like a New York thing. Most places we're talking about miles. That you agree that you're not going to practice for, while you're employed and for 2 years after within a 10-mile radius of the practice. Keep in mind, when we talk about that, we're talking about distance as the crow flies, straight line distance. It's not infrequent that we have folks that come to us and say, I found this great practice I want to buy, or I found this awesome location. The demographics are great for my startup, and I'm ready to proceed. And we look at the non-compete and say, well, you've got a 7-mile non-compete. And they've plugged that into Google Maps and they say, well, yeah, but it takes 7 miles to drive there in my car. See, I did the directions thing. I put point A to point B. That's not how these things are typically measured. They're measured straight line. So not the distance that you drive, but if you were the crow flying from A to B, how far that would be. And usually that's a lot shorter. So if you measure something and you say, well, yeah, 8 miles, I should be good at my 5-mile non-compete. Chances are that it's going to be a whole lot less. It might even be 4 miles as the crow flies. So keep that in mind. So where is the non-compete measured from? Where is the radius measured from? My old friend Jamie Amos, who was one of the founders of Ideal Practices, used to call this the Olympic rings phenomenon. So what he was talking about with that is, if let's say you were working for a practice that had 5 locations, and if you had a non-compete that you agreed to that said you agree that you're not going to work within 10 miles of any of the locations of your employer, you may find yourself in the Olympic rings scenario where you take 10 miles around each of their locations and you're restricted from there. And it overlaps a little bit, but if you take pi r squared here, with the example being, a 10-mile radius, each one of these is about 314 miles. Now, granted, there's some overlap, but we're more or less talking about like 1,300 square miles that you're agreeing that you're not going to practice. You've spent so much time, money, effort to get your degree, to get your license to practice dentistry. You shouldn't willy-nilly just give it up and agree that you're not going to be able to practice in large areas. And frankly, I think it's pretty unreasonable for an employer to ask you to agree to not work a certain distance from all their practices if there are practices that you didn't work in. So you need to be careful about that. The other thing with this is, it's not just that scenario where you say, it's measured around all their practices and there's some that you didn't work in. If it says that you agree you're not going to work within a 10-mile radius of any of the practices that you've ever worked in, well, it's possible that you might be just the good teammate. And if somebody's on vacation or somebody calls in sick, you say, sure, I'll go to that practice, or I'll go to this other practice. And so even though your main practice might be just 1 or 2 locations, if you then go to these other 3 periodically, or even occasionally, or ever, depending on what your agreement says, that might violate your non-compete. or that might trigger the measurement of the 10 miles, so that if you're working within that area, you violate your non-compete. So again, with all this stuff, it matters what's in the contract, contractual awareness, and it depends on what the agreement says. So another thing, sort of pet peeve, when I see people asking on Facebook groups, for example, what do you think of this? And people will chime in, this is what it means, or this is what you can and can't do. You have to read the agreement before you can say that. And so the problems, as Paul and I were talking about at the outset, with these types of issues, they can be avoided at the outset. When you're signing your agreement, when you're negotiating your contract, or having it reviewed, these are the types of things that you should flag and go back to your employer and say, hey, employer, I don't have a problem with a 10-mile non-compete, as long as it's measured around this primary location where I'm going to be most of the time. I don't want to get snagged in these other locations that I go out and cover on. And that's a reasonable ask. And if you're seeking employment from a reasonable practice or a practice owner, that's something that they should seriously consider. Similar to covenants not to compete, or another type of restrictive covenant, is a non-solicitation covenant. So what we're talking about is a covenant that says that you agree that while you're working for this employer, and for example, 2 years after, you will not solicit any of their patients. You will not solicit any of their employees, which means hire them, perhaps, or referral sources. But what does that mean? What can and can't you do? Again, it kind of depends what's in the agreement. And a lot of times it's kind of vague on this. So what is solicitation? Is it solicitation if you run a Facebook campaign or some sort of social media campaign for your startup office that former patients or patients of your former practice see? I don't know. Maybe, maybe not. If you advertise that you're looking for a hygienist, and one of their employees responds to that ad, have you solicited them? Maybe, maybe not. So you have to be really careful about what you can and can't do. And keep in mind with all of this, you don't have to be a bad person per se, or go and seek to violate these things. It's the appearance of impropriety that gets you in trouble. If it looks like you're doing this, then your employer might think that that is what you're doing. And that's when they call their lawyer and say, hey, we need you to send this demand letter or a cease and desist letter to our former employee who we think is violating the non-solicitation covenant. What you really have to be careful about too is, what impact does this have on marketing? So what used to be non-solicitation provisions back in the old days, when I started doing this in the early 90s, actually, without giving up my actual age, it would be that in order to solicit somebody, there was no email, there weren't websites. You basically had to steal a patient list and give it to your new employer or your office manager in a new office and say, hey, call these people and tell us where they can find us. That's not the case anymore. So, there's a lot of ways that we all market for our services now, through electronic marketing, social media, email blasts, things like that. You want to make sure that what used to be called the non-solicitation, and still under that same heading, hasn't morphed into something else that prohibits you or restricts you from being able to market for your new practice. Okay, this is a big one, daily minimums. So in a lot of cases, you should expect that you're going to be paid on a percentage of collections or production, but especially collections. That's probably the most common way that we see dental associates compensated. But that doesn't give you any kind of guarantee that the practice is going to be able to give you enough patient flow for you to make the money that you need to make. Or if you're working in an insurance-based, PPO-based practice, you may work for 60 days at least before $1 is collected for the services that you rendered from the insurance company. So in that case, you can be working away and there's no money coming in. So if you're being paid on straight collections, then you're not going to get any money. So what you have to be careful about, and we see a lot of daily minimums, I think it's a good thing. So for example, it might say that the employer agrees to pay you the greater of $700 a day or 35% of your net collections. What we see sometimes though is if what we call is a recoverable draw, and there's a difference between a recoverable draw and, as I say, a guaranteed minimum. A guaranteed minimum means you get it no matter what. And if you get that $700 because 35% of your collections was less than $700 or the collections haven't come in yet, that means you get to keep that money. Guaranteed minimum, daily minimum. If it's what's known as a recoverable draw, you may have to give it back. So in that example, if you have a draw of $700 a day, and let's just say the first month, no money comes in, so you wouldn't get any 35% of your collections. The difference between that $700 and 35% of your collections is the amount that the employer would deem you to be overpaid. And that as you are collecting more money later, they're able to go back and recover for the shortfall earlier. That is not a guaranteed minimum. That is a recoverable draw. And we're going to use some flags in here to illustrate some of these points. Is that a red flag? No, but it's definitely a yellow flag. And it's something you have to be really careful about. Typically, if we're looking at an agreement that's set up this way, chances are there's some other things in that contract too, because that's not really cool. It's a little deceiving and slightly disingenuous. And once we start to see someone do things like that, it makes us look under all the rocks. So again, be careful about recoverable draws. Daily minimums are great. Guaranteed minimums are great, but make sure that you don't have to give the shortfall back after you're no longer working there. Term, termination, notice to terminate. Okay, liquidated damages, we'll talk about that. So one of the big things here that we see when we talk about term is most associate agreements in the dental world are going to say that you agree to work for a year. That's the term of the agreement. Sometimes we'll see 2, but 1 year is overwhelmingly the most common term. However, the agreement then goes on to say later, either party can terminate at any time without cause for any reason or no reason upon a certain amount of notice, 30 days, 60 days, something like that. Be really careful about contracts that don't allow you to terminate without cause. This, I think, is a red flag. So I went for the first 20 plus years of my legal career representing dentists, and I don't think I ever saw a contract that the dentist couldn't get out of upon some notice. Now, sometimes it might have been 90 or 120 days they had to give notice to their employer, but there was always some way out. There are no givens that employment arrangements are going to work out for the long run, and that there might be personality differences, or the job may not be what it was offered up to you to be. You might not be making enough money, especially if you're being paid on a percentage of collections and you sit around and twiddle your thumbs most days. If you have a contract that says that you have to work for 1 or 2 years and can't terminate without cause, that's a big problem, because that means you still have to go to work every day, even though you're not making any money. So all agreements should have some provision in them that allow the associate to terminate without cause. Sticking with the term and termination. Be careful about contracts with extended notice of termination requirements. And what I mean is anything that's longer than 30, 60, maybe even 90 days we can live with. It's still a lot of time. We'll talk about that in a minute. But anything beyond that, I think, is unreasonable. Because look, if you are in a situation that's not working for you for some reason, or you've had a change of life circumstance, or you have a reason to switch jobs, if you have to give your employer a full season, 90 days, 120 days, 180 days, sometimes we say, notice before you can leave, that's going to be a very awkward situation. Not to mention, there might be a reason why you need to leave. Again, you're not making enough money, you're not getting enough mentorship, there's not the quality of the work environment is not what you would thought it would be. Your boss is not friendly to you, whatever the case may be. If you have something that makes you want to leave, or you have a change of life circumstance that you're moving or do something, you don't want to have to give that long of notice. The other thing is extended notice of termination periods are also problematic when you're looking to buy a practice. So if you're thinking you're going to transition into practice ownership at some point and you're going to buy a practice, it's very hard if you find the practice that you like and you sign a contract and then you say, okay, when are we going to close? Well, we're going to close in 180 days because I have to go back and give my employer 180 days notice before I can leave employment to buy this practice. Chances are that's going to kill that deal. So, any kind of super extended notice period, anything beyond 60 or 90 days, which I would consider the upper level of high normal, that to me is a red flag. Liquidated damages. So, as we talk about liquidated damages in the law are, it's a formula to determine how much somebody has to pay when they breach a contract when it's not otherwise easy to measure what the actual damages are. So without getting too far down into like a law school lecture here, an easy example would be if somebody has a contract that they're going to pay somebody $50,000 to do that, and then they don't pay that money, the damages are $50,000. It's easy. But in the case here where we talk about term and termination in dental associate agreements, let's say that you have an agreement that says that you have to give your employer 90 days notice of termination before you could leave. 90 days notice of termination without cause. If you have a liquidated damages provision in that case, it may say that for each day less than 90 days notice that you give, you have to pay the employer $500 per day. And again, the reason for this under the law is that how much is the employer damaged if you don't stick around for the full 90 days? It's hard to tell. It's hard to measure. It's not like that easy black and white example that if somebody fails to pay the $50,000 that they have in whatever contract, that there's $50,000 in damages. So again, the law allows you to set these formulas to determine damages when it's hard to measure them. And again, hard to measure damages when somebody leaves without giving proper notice. But you as the associate, you have to be careful. If you're agreeing to a 90, 120, or 180 day notice period, and then on top of that, you've got these, they call them liquidated damages, but frequently they're really penalties baked into the agreement that says that for each day less, you have to give hundreds of dollars back. You may find yourself in deep water if you're trying to leave the practice or you're having some kind of problem where you can't leave. You're not making enough money, you're in a bad work environment, and if you try to leave early, you're going to be penalized. It could be tens of thousands of dollars. And so what I would say with these, yellow flag, not red, but yellow, because we do see these a lot. It's not unreasonable to have liquidated damages, but the problem oftentimes doesn't really lie with the fact that there are liquidated damages. It lies with the fact that the notice of termination period is too long, so that formula, it might be $500 a day, for example, or $1,000 a day, can grow into a much larger number because the number of days you have to give is too long. So post-termination pay, this is a big one. Will you be compensated for collections received after you terminate? So again, if you're being paid on a percentage of collections, say 30%, and it takes 30 to 60 days for the money to come in for the services that you render, that means that if you leave on January 1st, that means that all the money that comes in for the work that you did in November and December may not have been collected yet. It's going to come in after you're no longer working there. If your contract says that you're not entitled to a percentage of collections received after you terminate, essentially, you're working for free the last 2 months. Sure, money's coming in, you're getting paid, but you're getting paid for things that had happened before. You're never going to get paid for the work that you actually did that last month or two. So be careful about those provisions. The other thing that we see that you need to be careful about is how are you going to be paid after notice of termination is given. We're seeing this kind of become an issue more and more where people give notice and the practice goes and they want to find somebody else and they're going to start transitioning other people to take over the production. Well, that might mean that you're working a lot less. You're seeing fewer patients. If you're being paid on a straight collection basis, there may not be enough money to make a living even. And again, if that period of time is for an extended period of 120, 180 days, and during that 6-month period, then you're making less and less for each month that you're there, you could find yourself in a financial problem. So I would call, the issue 1 is a yellow flag for sure, and issue 2, another yellow flag. These things almost kind of drift into like red flag territory, but definitely things that you need to be aware of and are things that you should try to fight back on when you are reviewing and negotiating your agreement. Next, number of days, hours of work. Is the practice committing to a minimum number of days, a minimum salary, or a minimum number of hours? Because what we often see in these agreements is it says that the practice, subject to patient demand, the practice agrees to, the associate agrees to work up to 3 days a week. Well, that doesn't mean that the practice is agreeing to give the associate 3 days of work. It just means that the associate's agreeing to be available to work should the practice ask them. So what you want to get is a commitment from the practice saying, yes, you are going to work 3 days a week, 4 days a week, 5 days a week, not you have to be available and we'll decide whether or not we want you to come in. Indemnification. When you see the words indemnify or the phrase name the practice as an additional insured, this should be a big yellow flag for you. Indemnify means that essentially you are agreeing to insure the practice. Without getting too far into the weeds with this, just seeing these terms should trigger you to realize that you have to go and get the advice of a lawyer to help you understand what you are agreeing to insure the practice for. Because if you agree to indemnify the practice for your malpractice, for example, that may mean that if you get sued for some negligence and the practice gets sued for negligence that you have experienced, then you are essentially becoming the indemnitor of the practice, which means that your obligation to indemnify the practice may undo your malpractice insurance. And so the takeaway here is that you may find yourself, if you agree to these things, where you get sued, the practice gets sued, and the practice's insurance company goes after you to cover their costs. So big yellow flag, those words, indemnify, circle that and talk to a lawyer. Name the practice as an additional insured, similar concept, circle it, talk to a lawyer, because oftentimes you can't name the practice as an additional insured on your malpractice policy, which means, again, if you're sued and the practice is sued for something that you did, you may find yourself as the substitute insurer. Independent contractor agreements. A lot of people think, oh, these things are great. I'm going to make more money. I could put more expenses through, and I could write off my car, my phone, and all this other stuff. There are some reasonable expenses you can deduct, but generally speaking, these arrangements are not as good for the associate as they are for the practice. Because even though the associate can put some expenses through the independent contractor relationship and write off some of those expenses and lower their tax liability, there are other taxes that are imposed for self-employed individuals, which if you're an independent contractor working for a practice, you are technically self-employed by the government's standards, which means that you have to pay an additional 15% of what you collect, which is the same as the deduction that the practice would make from your salary for Social Security and Medicare that you would then also match if you were an employee. So essentially, it costs you 7.5% more right off the bat to be an independent contractor. The other thing, though, with independent contractor relationships where we see people run into problems is from a tax planning standpoint. So if you are working as an employee, a W-2, commonly referred to as, the practice, your employer takes money out of your paycheck to make estimated tax payments. And if you're an independent contractor, that doesn't happen. So if you're not planning properly and setting aside enough money to cover your tax liability throughout the year, you may find out that you owe the government $60,000 come April 15th. And if you haven't set that money aside or made estimated tax payments along the way, you may find yourself in trouble there. So that's something, if you end up having to be an independent contractor, which we typically recommend that people try to avoid, you absolutely need to plan with your CPA to make sure you're setting enough money aside. Once again, the indemnification word, if you see indemnification in an independent contractor agreement, again, circle it. You got to talk to a lawyer, understand what you are agreeing that you are insuring the practice for. And in the independent contractor context, it could be that you are indemnifying the practice for any misclassification of you as an independent contractor, because practices and employers don't get to choose whether or not they want somebody to be an employee or an independent contractor. The government has a test to determine what classification you should be. And if your agreement has a provision in there that says that you agree to indemnify the practice for any fines, interest, or penalties that have been levied against the practice for misclassifying you as an independent contractor when you should have been an employee, then that means that you could be responsible for all those fines, interest, and penalties. So again, you see that word indemnification, that's a big yellow flag. You have to understand it. Lastly, what I want to say is just overall with these contracts, understand, again, they are important. Sounds silly to say. You might say, sure, Rob Montgomery, he's a lawyer. He says contracts are important. Yeah, of course, but they are. Realize that for most people, you're making it to this stage of your life where you've never had to sign a contract that has significant ramifications or that could contain different provisions or isn't uniform or standard. So this is, most people have signed apartment leases. You may have signed a lease for your Subaru. Those contracts are not contracts that are negotiable. And for the most part, they have protections baked into them under the law to make sure that you are protected as the consumer or the tenant. When it comes to employment agreements in the dental world, there are no such protections, and so if you're going to work for a DSO, for example, and they hand you a 25-page employment agreement, understand that is probably too lengthy by a factor of about 2 to 3 times. You need to understand what's in that, and don't assume that what's in there isn't bad for you. That there could be provisions in here that I said, non-compete issues, your ability to get paid, the amount of notice that you have to give, the indemnification that you might have to give them. All these things are bad things that could be in there. And there's no telling, because there are no two agreements are the same. It's what's in the contract that matters. And so you really mentally, you have to flip the switch at this time and say, okay, the old days where I could just sign a contract or a lease for a car and not read it are gone. I now have to read these agreements and I have to get help and consultation so that I understand what they say, so that I have contractual awareness to understand what's in my agreement to make sure that I don't find out the hard way when it comes time to leave my employment or when the employer is doing something that's not right. So I'll just finish up here tonight with a plug for my favorite dental podcast with my good amigo, Dr.
We
Paul
have
Goodman.
I can put it in the chat. Is that we have 132 episodes, right, Rob?
Something like that. I think it
Yeah.
might be more,
I
Paul.
think you just sent it to me. It was your team put together. I want to give it to Serena. They can put it in the chat. They can, you know what? If you listen to all 132, you know what you get? More free episodes. Um,
You might be
Serena,
crazy,
I
but
gotta,
hey, Paul, let me say this too, that with
sure.
this, there are, and the audience should know too, that Paul and I talked about and frequently talk about associate agreements and different issues that come up with associate agreements. And we did one whole, we called a season talking about these issues. It's sometimes hard to find episodes without having to search or scroll through. So if anybody has questions about, hey, what are the associate agreement episodes on the Dental Amigos? You can just go on our website, yourdentallawyer.com rather, and shoot me an email, and then myself or somebody from my team will send you the links and say, these are the episodes that are relevant to what you're looking to do.
Awesome, Rob. Well, I want to do, we have a couple questions. We have just a minute or two. I just myself want to bring up your info here for the group, how they can meet you. So, Rob, I want to add some context to this from your attorney angle. I know it's not legal advice, but we're just giving some feedback here. The difference between adjusted production and collections when you see that in contracts.
Right. So collections means that you get a percentage of the money that is collected by the practice for work that you did. Production means you get a percentage of the amount that's billed for the work that you did. So, if the day goes by, you do all your dentistry, at the end of that day, if you're being paid on a percentage of production, the practice should know how much money you're due that day, because it's not based on money coming in. Collections, you don't get paid until the practice gets paid. And if you're working in a PPO-based practice, oh, I don't know, 60 days it could be, 30,
Yeah.
90, who knows?
It should be sooner, but there's, there can be a lot of backlog, and that is something for people to really be aware of, because you could be working and getting 0, 0, 0. I want to ask you, Rob, with the concept of minimums, right? Daily, monthly, yearly, do you usually see them calculated daily, or have you seen ones calculated longer than that, where, hey, we're going to pay you this no matter what for a quarter and then square up? We're not going to take any money back from you, but we want your ramp. You might need some time to get ramped up.
Well, keep in mind too, so there's a difference between the daily minimum and this recoverable draw. If it's truly a daily minimum, they should never be able to take that money back.
Yeah.
Okay. I will say this is probably one of the areas in most dental associate agreements that's drafted really sloppily, where it's hard to tell kind of what that would look like for the associate, unfortunately.
And the thing about, I mean, I just share from my side of it as a previous associate practice owner. If you're getting a daily minimum, at least you're getting that money no matter what, right? And it's something you can count on. So I think that's key. The thing I think that, I don't know if you and I have even talked about this enough, but I want to make a point for this recording is many patients, Rob, at the time of this recording, come to us and say, my insurance is running out. I need to do my implant, right? And there's 5 weeks left in the year. And I say, great, Rob, but an implant takes 6 months. Okay. So you should have come sooner. And I think patients have a lack of awareness of how long dentistry takes. And I think dentists have a lack of awareness how long these processes take. I mean, I'm just asking, because I'm telling these people, get on Job Connect early, start looking for jobs. The process is someone kind of giving you a contract and people starting to work there. What's like a normal time frame, just so people are not coming to you the week before the owner wants it signed?
What I think should be normal is probably 2 to 3 weeks. But it's not uncommon, Paul. Yeah, that somebody, an employer gives somebody an agreement on Wednesday and says that they want it back on Friday. But that's somewhere between a yellow. That's an orange flag, Paul.
Yeah.
If the practice should really want to make sure that the employee understands the agreement. These agreements, shouldn't just be something that's like, haha, I got you. Like
Right.
something in here that you didn't know about. Surprise.
Right.
Now you're mine. So it's not fair, and it's just borderline unethical, I think, to give especially a new dentist an agreement without sufficient lead time to get reviewed. But I think, and again, this might sound self-serving too, but you really should kind of try to develop a relationship before you have the agreement. Like if the agreement, you get the agreement, and they say, well, we want this back, a week from, whatever, 10 days from now. like that could be a tricky time to start shopping around trying to find a lawyer who's going to
Right.
help you, right? And like we scramble to try to make those work for people, and sometimes we just can't, like
Yeah.
our workload is such that we've got
Well,
other clients who are
you
doing
can
things,
you can say this if depending on your relationship with clients, but we know dentists feel this right now, Rob. Someone's going to come in December to my brother, who you know, and say, "Why can't I get all this done?" But they already have other patients that they've scheduled,
Yeah, yeah,
and that person sometimes it's in or out of their control. But the reality is, he has a full schedule of other people that need help, and we
yeah,
can't just say we can't help those people. Just two more questions before we wrap up, Rob. In working with you for over a decade, I wouldn't have known this in dental school. When you look at a contract with someone, it could be an employment agreement, is wanting to make a change. It doesn't mean that you are a difficult client or you are not a good person to work with. Can you kind of share with the audience? It's normal for you to get this and say, hey, let's see if we can make an adjustment here. And
yeah.
then the dentist shouldn't be totally afraid of losing the job because of that. I don't know if I'm asking that the right way, but kind of if you could give us some insight on that.
No, I mean, it's a great point. There's a couple of things that I think we can unpack with that, Paul. Uh, I think that it's important yeah, you should realize that you do have the ability to make changes, especially reasonable changes. I will say though, if you are a new recent grad, this is your first job, you shouldn't expect that you're going to go through a contract and
Yeah,
negotiate and make changes like you're paying somebody $1 million for their practice. It's just
right.
not reasonable. So you really have to pick and choose the important things, the things that really matter, and I think there should be flexibility from the practice to correct that kind of stuff. And like one of the examples is, I'm not going to get paid a percentage of my collections for money that comes in after I'm no longer working here for work that I did. Well, like that's not right. Like
Right.
that's something you should be able to raise.
And
Or
I'll share as a practice owner, Rob, we had someone who became a periodontist. You helped with their contract because I told her to become a periodontist. And I worked really hard to get her the money she deserved because I know how hard dentistry is. So as an owner, we worked very hard after she was done to get her every dollar that came in, and also practice owners. I'm a practice owner. It doesn't last forever.
yeah,
We're not 2.5 years later. We'd have pretty terrible collection policies if 2.5 years later I'm collecting on an occlusal filling that they did. So to me, that really is nacho nuts. I can't understand it.
no, and so that's something you should be able to change. Or the non-compete. Now, there's your employer has 10 locations, and you agree that you're not going to work within 15 miles of any of their locations, and you only work in one. Like that's not right. You should be able to say, look, 15 miles is okay, but only around this one practice where I work, not all of your
Right.
practices. But I think
Yeah.
it's important to pick and choose. I mean, a lot of times we prepare employment agreements for practice owners. And I'll tell you, like if we get somebody that comes back and they're just making wholesale changes to things for the sake of changing them, we get frustrated and I feel bad for the associate in that situation. I'm like, this person's lawyer is negotiating them out of a job. Like
Yeah.
that's not okay. So this is where working with somebody that knows the industry, again, not trying to plug us, there are other people that do what we do, but that know kind of what's normal, what's reasonable, what to ask, what not to ask. But the other thing that I think it's important for people to realize, and this is a misconception I see with uh, young professionals that are hiring lawyers for the first time. So, like most of our clients, Paul, are hiring lawyers for the first time. It's kind of a crazy legal practice that
Yeah.
we have in that regard, but we like it, and it's fun. We like working with young professionals and helping them with these first contracts, helping them buy practices, helping them do their startups. But if you find yourself in a situation where the employer or whomever you're working with, the partner or partnership opportunity, somebody says, this is not negotiable. You can't make changes to this. That doesn't mean that you don't need a lawyer.
Right.
Okay.
Yeah.
You don't hire a lawyer just to negotiate. It's not like, the movies or TV shows where like back and forth, hammering out the negotiations.
Yeah.
I want 500,000. No,
Yeah.
400, right? What a lawyer does is to review these contracts to advise you and to give you consultation, to ask you questions, to understand what's important for you, to understand what, where you want to work, what your goals are, and then make sure that what's in that agreement don't run counter to that. But even again, knowing what's in there. I mean, and I'll put up 5 red flags for this, Paul. If somebody tells you you can't make changes to the agreement, you better know what's in that contract.
Yeah, yeah,
You know,
right. Because
Now,
yeah, I mean, there's some. We'll just keep them, all this evergreen in general. But there are some places out there that hire dentists where that's their reputation, and people say, I don't need to contact Rob because it's not negotiable. I said, no, no, that's
Right.
even more reason to contact Rob because when
Yes.
you want to leave and they don't want you to leave. So we'll ask one bonus question, but if you, the people that came here tonight, you should be so proud of yourself for taking time in the evening to learn this. I know some of you who are awesome already. I hope to meet more of you in person. But if you put one thing in the chat that you learned by being here, my team can do just one thing, an aha moment where you said, oh, I didn't think of that before, or gonna make sure I do that. I also want to share, Rob, and I'm like 98% sure this was one of your clients I referred. When new dentists say, "Oh, I don't have any money to hire an attorney," someone sold their articulator to pay for their contract review, and that was a good use of it because you don't use your articulator very often after dental school. Some prosthodontists will get upset, but when it comes to protecting your career, and you figure out how to get through dental school, I know you can figure out how to pay to get your contract reviewed. But my bonus question, Rob, is Larry David is famous for saying, or one of them, maybe it's not him saying, I would never join a club that would have me for a member, right? Or something like that. Like I wouldn't want to. So now let's just ask you when someone says, we don't need a contract, we'll just do a handshake agreement and come work for me. And we don't need a contract. I'll pay you. We're busy. I pay my associates this. We might come at this from different, I'm sure we come from different angles, but like, what are your
Yeah.
thoughts when you hear that? We don't need no stinking contract. It'll be fine.
Now, oftentimes it's not a bad thing. Most of what's in these agreements, Paul, are not good for the employee. They're not good for the associate, right? We've got indemnification, we've got notice periods, we've got non-competes. There's all kinds of bad stuff in here. There's more bad than good. And most states, when I say most, like there's only a couple that I know of off the top of my head that don't have laws that require employers to pay their employees. So just because there's no contract doesn't mean that the practice doesn't have
Yeah.
to pay you. Most of the hygienists and assistants and front desk, none of those people have contracts. They get paid every week. The dentist has to get paid too. Now, where that could be problematic is if you're trying to prove that you're supposed to make 35% of collections and the practice is only paying you 30%. But there should be some sort of paper trail out there that says, hey, come work for us and we'll pay you 35%. That's all you would need to do to prove that you were owed that money. Or the practice can't just pay you 35% of collections for 6 months and then stop paying you and say, oh, we're
Yeah.
not
Yeah.
supposed to pay you that. We're like, well, yeah, you are. No, go prove it.
Right.
Like, where's the contract? We don't have to pay because there's no contract. It doesn't work that way. It's somewhat of a misconception. Again, as a lawyer, is it nice to have everything documented in writing? Sure. But, after 29 plus years representing dentists, I know that most of what's in here is not good for the young dentist. So
Yeah.
you normally, and every situation is different, right? So this is not legal advice, and I
Yeah.
can't tell
Yeah.
you this is not all the time, but generally speaking, it's better off not to have one than to have one that has certainly than a bad one.
I think it's a good point. I think one of the things I see as someone who's in this world a lot is this that and it's might be an unfair brush to paint with because you're right about there's no restrictive covenant, there's no termination notice. Sometimes I see it as like a serious factor. We've hired multiple associates utilizing your help, and to me, it's like a way to say, hey, I want this to be a win-win.
Yeah,
This is what we're doing, and as a practice owner, a lot of times it's not necessarily a test, but it's just an experience I can
yeah,
have with an associate
yeah,
to talk to see how compatible we are, for a variety of reasons. So I
yeah.
appreciate you sharing that. Well,
I agree with you, Paul. It is sort of like, huh, what's up with this owner that doesn't like to do it?
that
But
was that joke, it's like I wouldn't want to join a
yeah,
club that would have me for a member.
but the good thing is, again, all these types of provisions that we're talking about, they all restrict your ability to leave, restrict your ability to go work someplace else. So I feel like when we see people get in the worst trouble is where they're like basically stuck in the practice.
Yeah.
They can't leave. They're not making enough money. They're not happy. They're not being treated right, whatever the case may be. And they've got these other things that just kind of keep them chained to the practice. I feel like even if you don't have an agreement and the practice doesn't live up to what they say they will, if you have the ability to walk out the door the next day and go get another job, that's not as
Yeah, you
bad
keep a lot
as
of freedom with that. And
yeah,
as we've seen and talked about on our podcast, there are groups, and it could be private, mainly corporate, that will have you sit there and do nothing because they need you to have the practice open, right? And they need
Yeah.
you to be there. And I've seen that many times through my DMs. And someone listening might say, why would you keep an associate who's not doing much work and not doing much? Well, because they're there, the hygiene can be open. Because they're there, they can see an emergency. And
Yeah.
then they're scrambling to replace them over that 60 to 9-day period. Well, amazing job, Rob. Thanks for everything.
Thank you.
Your website, the best website, if people listen to this last piece to go to connect with you and your team is what?
YourDentalLawyer.com.
Awesome, Rob. Thanks so much.